You're listening to Final Notice, real tax cases exposed with Jason Carr. Each week, we break down real Department of Justice tax fraud prosecutions and reveal what should have been done to avoid them. And now, here's your host, Jason Carr.
$8.5 million in refund claims, $1.7 million paid out, a Cadillac Escalade, crypto, a house in Mississippi, and 3 family members who failed to show up for day 2 of trial. That is not estate planning. That is episode 11. Today we're talking about Brandon Hunt, his father David Hunt, his twin brother Baylon Hunt, and his half-brother Corey Burt. The Hunts were from Arlington, Texas. Burt was formerly of Long Beach, Mississippi. According to the government, they ran a scheme involving false tax returns filed in the names of purported trusts they controlled. The word trust matters here. A real trust can be a legitimate planning tool. It can hold property. It can help with estate planning. It can help manage assets for beneficiaries. In the right setting, a fiduciary files Form 1041 to report the income, deductions, gains, losses, distributions, and tax liability of an estate or trust. But a trust is not a magic refund machine. The government said these defendants filed false claims for refunds in the names of trusts that were not entitled to those refunds. In total, they sought more than $8.5 million from the IRS. Brandon Hunt also filed multiple false returns in his own name seeking refunds he was not entitled to receive. And they didn't stop at returns. The government said the family members submitted additional fake documents to the IRS, including falsified financial instruments and altered money orders. That is the part where the paper trail starts sounding less like tax compliance and more like a craft project, a very expensive craft project. So how did this unravel? First, the IRS saw the returns. Then it saw the supporting documents. Then it sent warning letters telling them to stop making fraudulent submissions. That should have been the moment. If the IRS sends a warning letter and the issue is legitimate, you respond carefully. You gather records. You get professional help. You explain the position. If the position is wrong, you correct it. What you do not do is keep filing false returns and more documents. The government said that is exactly what happened. Even after the IRS sent warning letters, the defendants continued filing false returns and other documents. And the money moved. The defendants received more than $1.7 million in fraudulent proceeds from the IRS, and the government said they shared that money and used it to buy luxury goods, furniture, cryptocurrency, a Cadillac Escalade, and a house in Mississippi. That is another problem. Fraud cases are rarely just about the return. They're about the return, the bank deposits, the transfers, the purchases, the documents, the emails, the account records, and the explanations people give after the fact. Tax fraud leaves receipts, sometimes literal receipts. All 4 defendants were convicted at trial of conspiracy to defraud the United States. Brandon Hunt, David Hunt, and Corey Burt were also convicted of multiple counts of aiding and assisting in the preparation of false tax returns. Baylon Hunt was acquitted of 2 counts of aiding and assisting in the preparation of false returns. Then sentencing came. Brandon Hunt received 90 months in prison. David Hunt received 92 months. Baylon Hunt received 38 months. And Corey Burt received 94 months. Brandon Hunt was also ordered to pay $1,774,864 in restitution to the United States. And then there is one more detail. The U.S. Marshal Service helped apprehend Brandon, Baylon, and David Hunt after they failed to appear for the second day of trial. If you're already in federal court on a tax fraud case, skipping trial is rarely the move. By rarely, I mean never. So what should they have done instead? Let's assume someone walks into my office before this happens. They say, "Jason, I have trusts. I think the IRS owes them refunds. I have documents. I have a theory." Fine, we start with the theory. Not the refund number, not the hoped-for check, the theory. Who created the trust? What does the trust instrument say? Who is the trustee? Who are the beneficiaries? What assets are actually in the trust? What income did the trust earn? What deductions does it have? What payments were actually made? What prior filings exist? Then we look at the tax form. A real trust return is not a blank canvas. Form 1041 is used by a fiduciary to report the estate's or trust income, deductions, gains, losses, distributions, and tax liability. If the trust had income, we report it. If the trust had legitimate deductions, we document them. If income was distributed to beneficiaries, we deal with the K-1 reporting. If estimated taxes due, estates and trusts use Form 1041-ES to figure and pay estimated tax. What we do not do is invent financial instruments, alter money orders, or use a trust label to manufacture a refund. If prior returns were already filed and they were wrong, the next question is intent. Was this a misunderstanding? Was it bad advice? Was it a frivolous tax argument? Was it willful? Those distinctions matter because they determine whether we are in ordinary correction territory, audit defense territory, or criminal exposure territory. For non-willful mistakes, the path may be amended returns, corrected information, payment arrangements, and penalty relief. For willful noncompliance, the IRS criminal investigation voluntary disclosure practice may be an option if the disclosure is truthful, timely, and complete, and if it happens before the IRS has started a civil exam or criminal investigation, received the third-party information, or acquired information through criminal enforcement action. That timing piece is everything. You want to talk to a tax attorney while the door is still open. Once the IRS has sent warning letters, opened an investigation, or developed the case, your options narrow fast. So if you're a taxpayer listening to this, there's a practical lesson here. A trust is not a substitute for tax law. A structure does not create a deduction. A document does not create a payment, and a refund claim has to be real. And if you're a tax professional listening to this, the lesson is just as direct. When a client brings you a trust theory that produces an unusually large refund, slow down. Ask for the trust instrument. Ask for bank records. Ask for proofs of payment. Ask for the income. Ask for the authority. If the answer is mostly paper, confidence, and urgency, that is not a tax plan. That is a warning label. The takeaway in this case is simple. A trust can protect assets, organize family wealth, and help administer an estate. But when someone uses a purported trust to claim refunds that are not real, the trust label will not save them. The IRS sent warning letters. They kept going. That fact tells you almost everything you need to know in this case. If the IRS warned you to stop, stop. Get advice. Get records. Fix what can be fixed. Do not double down. Because in tax cases, stubborn can become expensive, and expensive can become criminal. I'm Jason Carr, tax attorney. If you want to make sure you never end up on this podcast, you know where to find me. cartaxlaw.com. Link is in the show notes. This has been Final Notice, Real Tax Cases Exposed.
If you enjoyed today's episode, share it with a friend or colleague who needs to hear it. Subscribe so you never miss a case. For show notes and more, visit cartaxlaw.com. This podcast is legal education and commentary, not legal advice, and listening does not create an attorney-client relationship. Full disclaimer at cartaxlaw.com.